Bismillahirrahmanirrahim. Distinguished guests, ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to everyone. Thank you for joining us for the Tun Hussein Onn Chair's public lecture on reforming the law to meet contemporary challenges. Delivering the lecture today is a man who needs little introduction and is one of the country's foremost luminaries on matters of the law, Emeritus Professor Datuk Dr. Shad Saleem Faruqi, the fourth holder of the Tun Hussein Onn Chair in International Studies at ISIS Malaysia. My name is Zainul, an analyst at ISIS Malaysia, and I will be moderating today's public lecture. Before I pass the floor to Professor Shad, please allow me to make some housekeeping rules. Today's proceedings will begin with a lecture by Professor Shad for about 40 to 45 minutes, and this will be followed by a question and answer session for about 30 minutes. The event should end by 11:30 a.m. Malaysian time. You may pose your questions to Professor Shad either by perusing the question and answer function on Zoom or by raising your hand to ask your question verbally. Also, Professor Shad's PowerPoint deck will be uploaded onto the ISIS Malaysia website by next Monday. I hope those who are interested in taking a closer look at the lecture material can access it then. With that out of the way, and without further ado, may I please have the honor of inviting Emeritus Professor Datuk Dr. Shad Saleem Faruqi to deliver his public lecture. Thank you.
Assalamu alaikum warahmatullah. Good morning. Peace be upon you all. And Zainul, ladies and gentlemen, it's my great honor to be addressing you on this topic of reforming the law to meet contemporary challenges. Now, as the year and the decade come to a close, we thank the Almighty for His many blessings. At the same time, we pray for riddance from the strong turbulence that buffets our nation's political, legal, social, and economic shores. Some of the problems that are lapping at our feet are rooted in the past. Some, like COVID-19, are global and extraterritorial in nature. But whatever the origin, it is for us to tackle the challenges with courage and imagination. Reforming some of our laws, institutions, and procedures will be one of the ways of meeting the felt necessities of the times. I emphasize one of the ways because law is not the only way of solving the problems of society. In this presentation, I wish most humbly to propose the setting up of an independent law reform commission or law reform institute, and to highlight some areas of the law which are ripe for review in the light of the special problems we are facing today. Let me now caution about reform, the limits of the law. In pushing for law reform, a few words of caution need to be administered. First, there are limits to what the law can achieve. The law is just one and not necessarily the most important factor and force that molds society. Beyond legal institutions, there are economic, religious, social, cultural, and educational forces that play a crucial role in our lives. But these are outside the scope of our discussion today. Second, institutions are as good as the people who administer them. The need for able, honest, and visionary leaders and public officers with integrity is just as important, perhaps even more important, as proper institutions and procedures. Third, in seeking reform, we must balance idealism with pragmatism. It is not what the law says, it is what it does that is important. Not only form, but functioning. Not only content, but consequence. must be measured. Fourth, many problems like poverty, economic disparity, and gender discrimination are systemic and structural and require remedial approaches that are holistic. And I have to say this to you, Mr. Chairman, that democracy is suitable for piecemeal, elastoplast solutions. Democracy is often not so suitable for systemic or structural solutions to problems. So that's an issue of democracy and reform. I humbly propose a law reform commission so that the law is kept dynamic and in tune with the times. We'll all agree that life is larger than the law. The nature of the law is such that its whole body is potentially in need of periodic review. The task of reform is so mammoth that no one institution can handle reconstruction of the law single-handedly. And I have no pretense that a law reform commission is the only institution that can bring about law reform. Judges, through activist interpretation, can bring about development in the law. But judicial reform is piecemeal and depends on the accident of litigation. The Attorney General's Chamber has a special law revision and law reform division, but it is overloaded with other work and priorities. Ministries and statutory bodies often appoint ad hoc committees to draft legislative proposals. But the ministry tends to be reactive rather than active, rather than proactive. It reacts, it doesn't really act to nip problems in the bud or to anticipate problems. NGOs make valiant suggestions now and then for law reform, but mostly without success. Parliament can enact new legislation or amend or repeal existing laws. That's actually the raison d'etre for its existence, the reason for its existence. But sadly, due to a very passive view of its constitutional role, our Parliament is content to play second fiddle to the executive in law initiation and law reform. I'm sad to mention this. Parliament has been captured by the executive. Parliament legitimates, it does not legislate. So we need an independent body, an independent law reform commission or a law reform institute with a power to act on its own initiative as well as on the request of the AG or the Ministry of Law to keep the streams of law flowing and healthy. Next, the tasks for the commission will be many. Almost always, the wide gap between the theory of the law and the reality on the ground is discernible. So that's, I think, the first task, to keep the laws under review, to see how far the law is functioning well. Not how good the law is in its content, but in terms of its consequences, its functioning. And I go to slide 13. The commission, when appointed, must exhibit some essential characteristics. It must be independent of the executive. Its members must be drawn from all sections of the legal community, including the judiciary, the bar, the academia, the AG's office, and law-trained persons serving as legal advisors to companies and corporations. The luminaries appointed must have expertise, they must have tenure, and they must be having a full-time job. They must be supported by full-time research and administrative staff. Now, the Commission's approach must be interdisciplinary, socio-legal, and not confined to what is called lawyer's law. The Commission must explore the actual working of the law in practice. Its methodology must be consultative and implementation-minded. This is very important, actually. Community participation in law reform will achieve many important purposes. First of all, feedback will be obtained and a sense of public ownership over the process of lawmaking will be fostered. Decisions in which people participate are decisions they are likely to respect. Next slide. The remedial aspect of the law must not be ignored. Justice is not in legislation, but in administration. Quite often the law gives a right, but the remedies are impractical, too expensive, too dilatory, too technical. And actually, a right without a remedy is like a light that does not shine and a fire that does not glow. So we need effective remedies. In my humble view, and this is something very close to my heart, but I haven't got very far with it, Mr. Chairman. I believe that every act of parliament must contain towards the end a provision for appointing a body of citizens and experts to examine the law's actual operation in society and to suggest reforms. So let us say Parliament passes the EQA, Environmental Qualities Act. In the EQA itself, there should be a clause authorizing the minister to appoint a committee of experts to yearly report to the minister on the working of the law and the need for reform. So in other words, every act of parliament should be kept under review as to how it is working. Now, reforms that I wish to propose for today must address the following urgent and impending threats to society. I wish to state this, Mr. Chairman, that my list of about 10 topics is influenced by the peculiar problems we are facing today. This is not a comprehensive list at all. These are the felt necessities of the times today. First of all, the political instability caused by party-hopping legislators. Someone called them mobile assemblymen. Mobile. So, political stability. Governments are rising and falling. In Perak, in the last 2 years, there have been 3 appointments. Now, this is shameful indeed. Identity politics and decline of social harmony, I think, is a serious problem. Endemic corruption, especially elite corruption. Need for more openness in government and the need for a Freedom of Information Act. Decline of all check and balance mechanisms and the rise of an uncontrolled executive. Serious discontent in federal-state relations, especially in relation to Sabah Sarawak. The eclipse of some human rights. I wish to emphasize this, Mr. Chairman, that human rights have a very broad dimension. Besides civil and political rights, there are also socio-economic rights. In general, Malaysia has done fairly well in terms of preventing starvation, in terms of providing basic necessities of life. But in some areas, there are real problems. So, eclipse of some human rights. Absence of sustainable development policies and politicization of the public services. May I go to the number 1 issue, current issue, party hopping and political instability. Though party hopping by mobile MPs and assemblymen has been known in the past in states like Sabah 1994, Perak 2009, this phenomena has become so endemic lately that it is creating chronic political instability. It is causing the fall of elected governments every few months in several states. We noticed Perak. Now, results of general election are nullified in backroom deals. Issues confronting the nation are given lesser attention than the struggle to retain power. Political ethics and political legitimacy are at an all-time low. I think citizens' perception of our government and of our politicians certainly has suffered, and I think this needs to be rectified. Along with having legality, the government must have legitimacy. And I think that's a problem that we are facing. Yet there is no law to control defections. By defections, I mean party hopping, crossing the floor. Now, instead, I'm sad to report the case of Nordin Saleh, 1992, says that the right to defect is part of freedom of association. In Article 10, Clause 1C, it's right to associate, disassociate, and reassociate. With all due respect to the learned judges of Nordin Saleh, they gave insufficient importance to the constitutional provision in Article 10, brackets 2, brackets C, that the freedom to associate can be restricted on several grounds, including morality. Morality is a ground to restrict freedom to associate. Morality need not only mean sex morality. Political morality is also morality. But the judges interpreted the word morality to refer to conventional sex morality only. I think this was a serious error. And we are now suffering the result of this terrible judicial decision. May I point out to you that 41 countries in the world, including Bangladesh, Fiji, India, Israel, Pakistan, Portugal, Singapore, Sri Lanka, Thailand, have laws against party defections. In 8 countries, including Singapore, these laws are enshrined in the Supreme Constitution. Now, I wish to confess that the pros and cons of anti-hopping laws are many. There is a lot of support for freedom to associate. It's part of fundamental right. Anti-hopping laws will make party bosses too powerful, will prevent MPs from standing up to their party leaders. So there's a lot of arguments, pro and con, but in general, I wish to propose that in the circumstances that we are living through, our law should be amended to overturn the Nordin Saleh precedent and to require some control on the activities of MPs who wish to hop parties. I think the law should require a resignation if an MP wishes to change parties. But to honor his right to associate and reassociate, he should be required to return to the voters to renew his mandate. So if I went to the voters last time on a particular party platform and they elected me and now have changed my mind or changed my ideology, I must return to the voters to seek a fresh mandate. However, there are problems in Article 10 to C, Article 48, Clause 6 that need to be looked into. But nevertheless, I think we need a law against defections. We need to honor the power of the electorate so that the electorate decides whether a person who has now suddenly changed his ideology deserves to be representing them again. We must limit the number of cabinet posts. A further measure to discourage mid-term aisle crossing for corrupt purposes is to provide an upper limit to the number of cabinet appointments that the PM or the Ketua Menteri or Menteri Besar can make. Sadly, the federal constitution provides no maximum in the number of cabinet ministers. But most of our state constitutions provide a limit on the number of EXCO members. I humbly propose that the limit should be no more than 10% of the total number of MPs. So if there are 222 MPs, 10% of that would be about 22, I think. Then we must broaden the definition of office of profit. MPs are disqualified from holding an office of profit. Article 48, Clause 1, Subclause C. Unfortunately, the term office of profit is so narrowly defined in Article 160, Clause 2, that it basically means whole-time office in any of the public services. And public services are defined in Article 132 to refer to the police, the army, education service, statutory bodies, GLCs are not part of public services. So the result is that MPs are given posts in GLCs, in Quangos, in statutory bodies, lucrative posts, and that's an attraction to switch camps in order to be able to reward it. So I think we need to broaden the definition of officer profit. Then next point is about budgets. It is a constitutional requirement in Article 96, 99, 100 that governments must apply annually to Parliament for raising and spending money. That's an excellent rule. We must return to Parliament for raising and spending of money. The only problem is this: what happens if the budget is defeated? The British Convention is or used to be that a budget defeat would amount to a vote of no confidence. Now, the result is, therefore, that a government that is a coalition government, a government that has a narrow majority, is always in danger of being defeated during the budget time. And therefore, compromises here and compromises there will have to be made. I humbly suggest that the Constitution could be amended to allow an elected government, once it is in place, once it is on the saddle, to present supply bills and finance bills every 2 to 3 years instead of annually. Once the government comes to power, it should present a supply bill or a finance bill, not just for 1 year, but possibly for 2 or 3 years. So this drama or this nightmare of a budget defeat doesn't occur annually. Then I go to the next point, number 2, decline of social harmony. May I say this, that for decades, Malaysia was an exemplar of peaceful and harmonious relations amongst its dazzlingly diverse population. Our constitution, with all its flaws, was a masterpiece of moderation and compromise, and showed consciousness of the social, economic, political, and ethnic realities of our land. All of us who have traveled abroad in the earlier decades know actually how many people abroad used to look up to Malaysia, especially in Asia and Africa, for the way Malaysia handled inter-ethnic relations. But there has been a lot of regression in peninsular Malaysia. The spirit of the Constitution has been compromised. Racism and related bigotry are replacing the admirable centuries-old Malay tradition of inclusiveness and moderation. Sabah and Sarawak are, however, different and supply useful paradigms for inter-communal relations. I think we need a National Harmony Act. May I point this out to you, Mr. Chairman? Lots of people talk about the need for hate laws to punish hate speech. I want to adopt a more constructive and positive approach. Instead of using the sledgehammer of the law, criminal law, to punish, I would rather have a more constructive and positive approach of a National Harmony Act or a National Unity and Integration Commission Act, by whatever name it is called, to achieve 3 purposes. Number 1, positive engagements between the races, the regions, and the religions. Most prejudices are born out of ignorance. If people could be exposed to each other's views, each other's perspective, if they could be told that there are many views of the garden, I think many of these prejudices will dissipate. So, positive engagements. Conciliation procedures when disputes arise. This approach may be an alternative to the sledgehammer of laws like the Sedition Act and the Penal Code. And thirdly, penalties. If conciliation fails, then penalties, not necessarily criminal, when conciliation fails. For example, if I have made hate comments, perhaps a solution may be to force me to attend a small course and listen to people who talk of love and understanding. So penalties, not necessarily community service type of thing. Many models exist, Mr. Chairman. UK and Singapore, for example, provide us with good blueprints. Then may I humbly recommend Rukun Nagara as a preamble to the Constitution. We all know about the Rukun Nagaras, but actually, may I point out that the 5 principles of the Rukun Nagara are well known, but the 5 studying objectives have been generally ignored. The objectives are unity, a democratic way of life, a just society where the prosperity of the country can be enjoyed together in a fair and equitable manner, a liberal approach. The word liberal occurs in the Rukun Nagara, a liberal approach towards our rich and varied cultural tradition, and a progressive society that will make use of science and modern technology. Our constitution doesn't have a preamble. It would be great to adopt the Rukun Nagara as a preamble to our constitution. Then I go to the issue of endemic and brazen corruption. Now, I have to say this, corruption exists everywhere in the world. In the best of democracies, corruption exists. However, the problem that we are facing is that the check and balance mechanisms, the enforcement mechanisms, those are not working so well. Corruption in the public service has become a serious problem. Now, I humbly propose one solution, and that is this, that we must show concern for the fact that civil servants often do favors in return for lucrative positions in this sector after retirement. So they do favors to a sector to which they have a chance of joining after their retirement. There is no rule barring a civil servant from working for a prohibited period in an industry connected with his official work. I think there should be such a rule. For 3 years after you retire, you cannot work in the industry which you were regulating while you were a top civil servant. There should be a separation of the offices of the AG and the public prosecutor. The AG is the government's chief lawyer, the government's chief defender, and he should be. But then he's also public prosecutor. But the public prosecutor's task is to protect the public interest, to promote criminal justice, and therefore there is a conflict of interest when there is a need to prosecute ministers or public servants. And clearly we saw this in the problem of one MDB a few years ago. The Malaysian Anti-Corruption Commission was established with high hopes. I think reforms are needed for the MACC, Anti-Corruption Commission, to function independently with established structural protection from executive control. The Anti-Corruption Commission should be upgraded to constitutional status. I think it should be in the Perlembagan. In some countries, they call it the Integrity Commission. The present rule for it to obtain permission from the Attorney General to prosecute must be abolished. But that will require amendment to Article 145 of the Perlembagan, because the AG, Attorney General, has the monopoly of initiating or not initiating prosecutions. So the MACC should have its own independent prosecution powers. Amendments to related laws such as the Whistleblower Protection Act and the Witnesses Protection Act are also recommended. We badly need, Mr. Chairman, we badly need a government and public authority procurement act to regulate tenders. All tenders and public authorities must be regulated so that there is no temptation for corruption. The Whistleblowers Protection Act is a good law. It provides protection to whistleblowers, but its main limitation is that the disclosure that is protected must be to the relevant enforcement agency. If it is to a non-enforcement agency, there is no protection. So if you were my MP and I go and report to you as to what is happening in my organization, I'm not protected. But if I report to MACC, then I'm protected. So I think the protection must be a little bit broader. Next one, there is need for more openness and transparency in government. Regrettably, though our constitution gives freedom of speech and expression, it does not anywhere confer this right to know. there is no right to know in Article 10. However, there are scholarly and judicial opinions that the right to know is implicit in the Constitution's right to speech and expression. An idea is galloping around the outskirts of the legal system, Mr. Chairman. The idea is that human rights must be interpreted prismatically. The human rights that are granted by the Constitution must be interpreted prismatically, holistically. So like when a ray of light hits a prism, it comes out the other side in many, many colors. So the idea is that along with the enumerated right, there are other derivative, implied, non-textual, unenumerated rights. And I hope and pray that this type of interpretation will take hold in the years to come. Now, instead of a right to information, we have an Official Secrets Act imposing a duty to stay away from all classified information. Now, while it is undeniable that some government information must remain confidential, for example, police investigation papers, cabinet meetings, foreign relations, the catch-all provisions of the OSA must be tested on the anvil of Article 10, Clause 2, which permits restrictions on free speech only on 8 enumerated grounds. My point is this. The Perlembagan gives freedom of speech and expression in Article 10, Clause 1, Subclause A. Article 10, Clause 2, Subclause A says, free speech can be restricted on 8 grounds. Public order, national security, incitement and offense, friendly relations with other states, contempt of court, contempt of parliament, defamation, morality, 8 grounds. So in my view, if you are the government servant and you wish to classify an information, you must be guided by these 8 grounds. You must classify information because it would be a threat to public order, national security, incitement and offense, etc. You should not have the freedom to classify anything you like. And that's what is happening actually, that public servants basically classify anything they like as a classified information under the OSA, even though it may not be connected with the enumerated 8 permissible grounds. A good example would be this. The Auditor General's report on 1MDB was classified under the Official Secrets Act. The OSA should be replaced with the Freedom of Information Act. In fact, Penang, that's slide 32, Penang and Selangor gave us good illustrations of Freedom of Information Act laws. However, these state laws are subordinate to the OSA. The state may release, but the OSA may classify, in which case the Official Secrets Act will prevail because security is a federal matter. Now, when I say there should be freedom of information, I'm conscious of the fact that just like in the OSA, not all pieces of information can be released. So the Freedom of Information Act, like the OSA, must clearly contain categories of information that cannot be released. The FIA, Freedom of Information Act, should also acknowledge the existence of valid laws and principles that constitutionally restrict the disclosure of information. Among these are Banking and Financial Institutions Act, Criminal Procedure Code, Data Protection Act, laws on privacy, laws on confidentiality, and what is called in law the public interest privilege. So the point I wish to make is this, that we should not get too carried away with the right to know. I have to alert all listeners, freedom has to be balanced with the need for some confidentiality in respect of some categories of information, because freedom per se has no value. It's what freedom is for. It's the use to which it is put. It's the sense of responsibility and restraint with which it is exercised. Media freedom is important to ensure that the media is free to act responsibly in the public interest and hold the government to account. And I think some reforms to the Malaysian Communications and Multimedia Commission are vital. May I go to slide 36? Decline of all check and balance institutions. The Constitution and the laws have created a number of check and balance institutions and procedures. Among them are the Parliament, the courts, the AG, Auditor General, Election Commission, the Police Force, and a host of commissions and councils under the Constitution. Regrettably, most of them are not living up to their promise. I think we need some reforms. This is slide 37. We should have one or more ombudsmen. You can call him by whatever name. In the UK, he's called Parliamentary Commissioner of Administration. In Islam, he would be called Muhtasib. We should have one or more ombudsmen who should report to Parliament, as in the UK. Of course, an independent law reform commission, a electoral process should be reformed to look into the first past the post electoral system. Regulation of political financing is an urgent need. Local government elections must be reintroduced. Something controversial I have to point out, Article 48, Clause 4. It creates a bad impression, Mr. Chairman, that MPs who are convicted of serious crimes can continue to sit in Parliament because their appeal or petition for pardon is pending. I'm fully in support of the view that if an appeal is pending, stay of the conviction order can be granted. But for an MP to continue to sit in Parliament appears to me to be not in harmony with the rule relating to public servants. When public servants are prosecuted for crimes, they are interdicted. If they are convicted, automatically they are suspended, even though there is an appeal pending. So why the double standards for public servants, 1.6 million public servants, and MPs? I think there should be change in the law, Article 48. May I go to slide 40? West Malaysian leaders must take note of the serious discontent in Sabah and Sarawak over the perceived violations of their negotiated 1963 rights, issues of income sharing, cultural, religious, and linguistic autonomy. Now, I want to say this. Tensions in federal-state relations are perfectly common and normal in every federation. I also want to say that these tensions are being taken note of, and I think West Malaysians must be more accommodative of Sabah Sarawak's discontent. There is a need to strengthen human rights. There should be implementation of the outstanding recommendations of the 2005 Royal Commission of Inquiry into the Police. Next one. Next slide. The government must address issues in the immigration department like smuggling and human trafficking. It must establish the facts behind the Wang Kalian migrant death camps. Next one. Though many strides have been made, gender equality remains a distant dream. Despite Article 8, Clause 2, which says gender discrimination is forbidden, laws on citizenship and native status openly discriminate against women. For example, children born abroad to Malaysian women are not granted citizenship rights on the ground that would be a threat to security because the child may have a double citizenship. But the same would apply if the man, if the father is abroad and the child was born abroad from a Malaysian father. So Malaysia is only one of 25 countries that does not grant equal rights to women in this area. Evidently, there are 40,000 pending applications from Malaysian women seeking citizenship for their kids born abroad. May I also point out in the area of equality that beyond formal equality, there is functional equality. The picture is far more unsatisfactory if social reality were taken into consideration. Conflict of civil and Sharia court jurisdiction must be resolved. The plight of the disabled must be noted. Judicial decisions that human rights provisions of the Constitution do not apply in the private sector must be reversed. There is an Article 8 equality before the law, Article 8 Clause 2. Judges have said Article 8 protects public sector, doesn't protect private sector. To me, that's a serious flaw. Because, Mr. Chairman, tyranny is tyranny, whether in the public sector or private sector. A great many violations of human rights are actually in the home, in the workplace, in the rubber estate, in the factory. So I think the shade of the Constitution must be available everywhere, and not only in relation to the public sector. Prisons and detention centers must be humanized. Orang Asli land rights must be protected. Article 8, Clause 5, Subclause C actually allows protection, special protection for the Orang Asli, for the aboriginal people. This has not been adequately utilized. The plight of stateless persons. I know they are not citizens, nevertheless they are human beings. Stateless persons, asylum seekers and refugees must be looked into. The spouses and offsprings of the above require humane consideration. Children, often illegitimate. The mother may be an illegal immigrant. The father was actually a Malaysian in a relationship with her. And children are therefore illegitimate, and they face difficult issues that have human rights implications. Better studies are needed to measure extreme poverty and extreme inequality. The recent UN report puts our poverty rate at 15%, whereas official reports state to be 0.4%. I am not in a position to comment on which report is more reliable, because statistics are a matter of opinion. My guess is this, that perhaps extreme inequalities are distorting the true picture of deprivation. I'm reminded, Mr. Chairman, of the skeptical, humorous comment which said, if you have your head in the oven and your feet in the freezer, on the average, you are comfortable. So if there is extreme poverty on one side and extreme wealth on the other, on the average, you're okay. So I am not in a position to interpret statistics. All that I know is this, that we need to engage with the UN people to see how they worked it out. We need to tell them where they are wrong, and they need to tell us where we have made a mistake. I also know that the COVID-19 storm has obviously affected all measurements. I also know that the government statistics were of, I think, 2017 and 2020 things have obviously changed because of COVID. As a non-economist, all that I can say is this, that Malaysia's political economy has definite structural problems. For example, I all along had read about NEP's 30% Bhumi equity ownership, but I was always wondering, the 30% Bhumi equity ownership will do very little for the non-equity owning Bhumiputras. So even if Bhumiputra, rich Bhumiputra owns equity, that doesn't necessarily help the plight of the poor rubber tapper. So there are structural issues of how you measure poverty, how you measure upward mobility. Urban poverty and the problems of the aging population require attention. I'm told that in 20 years' time, 80% of our population will be urban. I'm told that up to 70% of the population has now become urban. So these are significant human rights considerations. Yes, I forgot to mention aging population, the problems of the aging population with the rise in our survival rate. I think aging population. We need to adopt sustainable development goals. Mr. Chairman, growth for the sake of growth is the ideology of the cancer cell. So development policies and decisions must take note of environmental considerations, because if we don't, in the long range, this will destroy mankind. Environmental issues have human rights implications, and the plunder of nature for the benefit of the few must be prohibited. In some countries like India, courts are prepared to allow public interest litigation to grant locus standi to applicants who go to court to protect rivers and forests. So if the rivers and forests and the farms are being destroyed, and the poor who depend on the river for water and for fish, for their protein, their lives are being destroyed. They don't have the knowledge or the resources to go to the courts. Other groups under something called public interest litigation may be able to go to the courts, and the courts are granting locus standi to protect rivers and forests. Human rights theory, Mr. Chairman, recognizes the rights of future generations, not just our rights today, the rights of future generations, the rights of our children and children's children. In some countries like UAE and Norway, sovereign funds have been established to save a certain percentage of the income from our natural resources for future generations. Some scholars are recommending that there should be a Natural Resources Act to regulate all our natural resources. It's an excellent suggestion. The problem is this, that we are a federal state. Forests, rivers, mines are in state jurisdiction. So there will be a problem of federal-state relations if we want to have a Natural Resources All Malaysia Act. Nevertheless, this is something that needs to be looked into. Politicization of the public service is a serious problem. May I please go to slide 50? Public servants, 50. Public servants with professionalism and integrity can do much to provide a break against the over-exuberance of politicians. I think, Ali, that's the two more slides. Next slide. Next one. Yeah, that's them. Public servants with professionalism and integrity can do much to provide a break against the over-exuberance of politicians, the disregard by many politicians of the Constitution and the laws, and the indulgence by many of them in corrupt practices. Behind the scenes, top public servants probably do supply the needed constructive critique of governmental policy. But the public perception is, and this perception needs to be tackled, that politics reigns supreme and the check and balance has broken down. Perhaps this perception is existing because of the financial tragedies relating to 1MDB, Tabong Haji, EPF, Felda, Mara, Bank Negara, PFI, and they seem to indicate that there was a serious breakdown the check and balance role of civil servants. Finally, last slide. In sum, there is much to be done. Our approach up to now has been reactive. We react to problems after they arise, and then we offer piecemeal proposals. Instead, we must establish a proactive, participatory, and people-centered law reform commission or institute to keep the streams of law flowing. Let us harness the power of informed and committed citizens for promoting the national good. On our part, all civic-minded citizens must give cooperation to existing law reform institutions and help to plant the seeds that may lead to the greening of the landscape of ideas. Thank you very much, Mr. Chairman.
Thank you, Professor Shad, for the insightful lecture. With that, we can now move to the question and answer session of this public lecture. And once again, may I please highlight the two ways you may pose your questions to Professor Shad. The first is by typing your question by using the question and answer function on Zoom. And the second is by using the raise hand function and asking your question verbally when I call you out. There are, let's see, 4 questions currently in the Q&A section, but I think I'm going to abuse this moderator's privilege and pose something to Professor Shad first, right? Hopefully get the conversation more lively. Prof, I agree with, I think, literally everything you just said and presented over the past hour. They're brilliant points, right? But what's stopping those ideas from becoming reality? It's definitely not on the ideation stage, because I think anyone with a reasonably good mind would appreciate that. But what's stopping them?
There are many factors. One of them actually is basically practicality. As I mentioned, the AG's office is overworked, overburdened. They have priorities. Quite often you go to them with proposals and actually they've got other priorities. Second, of course, is the issue of what could be called the political economy. So great many reforms, for example, in terms of sustainable development can be made, but if that is done, if these reforms are made, that would definitely affect the interest of the elite. And everywhere in the world, including the USA, UK, there is a state within a state. There are the institutions which are often referred to as the deep state. So they prevent these changes. So I think it's the reality is everywhere in the world, democracy is regarded as a government of the people, for the people, by the people. In reality, everywhere in the world, democracy has become a government of the elite, for the elite, by the elite. So I have to say this, traditional electoral systems need to be reformed. And parliaments are called people's representatives. Actually, parliaments have become elite institutions everywhere in the world. In the USA, I'm told 60% of congressmen are millionaires. 60%. The gun lobby, the farmers lobby, the pharmas, they control lawmaking. Can you imagine more than 30,000 people a year die of gun violence? In the US, there can be no gun control. So I'm afraid we need to have incisive, frank, if need be, private discussions on the issue of how parliaments have become captured by elite interests, and our democracy now actually has degenerated into oligarchy everywhere in the world. I think that's why many of these reforms don't get made. I'm just giving you one example from my field of constitutional law. Salaries in the public sector. I'm told the minimum wage is something like 1,050 minimum. But look at the upper limits. And if you add to the upper limit, the allowances that the top civil servants get, disparity is incredible. Please don't get me wrong. I'm not jealous of people earning take home 200,000 ringgit per month in the GLCs, and I'm not jealous of that. I'm just a law teacher. Nevertheless, as a student of law, it occurs to me, this one is a human being, and this one is a human being, and the question of whose work is important to the nation? Is this work more important than the other? I think there should be some sense of balance. I agree with you. These ideas have always been there. They have been galloping around the outskirts of the legal system for a long time. But the doors have not been opened.
Thank you, Professor Shad. Yeah, I was just going to make a comment that maybe in the US, you become a millionaire and then you become a representative.
Then you become a rep.
But here, I think you become a rep, then you become a millionaire.
Indeed, that is true. That is true. That is true, yes.
Okay, I think it speaks to the land of opportunity that Malaysia is. Let's look at it. Powerful. Prof, okay, let's move on to the Q&A section. Andrew Koo posed a question by stating that the Pew Research Center in the US, in its research on government regulation and social hostility, had shown that Malaysia's social hostility index had markedly worsened over the past decade or so, even as there being an increase in government regulation. Does this not suggest that we need less laws rather than more?
Oh, I'm fully in agreement with Andrew that the social hostility has gone up. Actually, I did mention this in the essay, though I may not have read it out. We are suffering some paradoxes. I'm talking of social hostility. The paradox is this, that as long as governments are weak, the majorities are thin, there will be a tendency to rely on race, religion, and region to attract votes. On the other hand, if the government was stable and strong, with a comfortable majority, it could afford to be more accommodating all sections of society. So that's the paradox. The paradox is this: accountability is lesser if there is a massive steamroller majority. Accountability is lesser, but a strong government can afford to be more accommodative of all interests of society. Sadly, in our society, the social hostility index is going up because governments have grown weaker, and therefore they pander to public opinion. I think Jesse Jackson had said, leaders of substance don't follow opinion polls. They mold opinion, not with guns or dollars or position, but with the power of their souls. But we are having a problem. Now, on the other part, we need lesser laws. Actually, Andrew, in general, I am not in favor of too many laws. In my personal view, for example, the penal code is good enough to punish insulting behavior, religious insults, racial insults. But in addition, we have the Multimedia Act, and we have the Sedition Act, and a number of other laws. I have no objection to this idea. To me, the very important thing is this. First of all, there must be a leadership that censors these things. So if an MP utters racist or gender-biased statements in Parliament, even if he's immune under Article 63, parliamentary privilege, I think he should receive censure from his party leadership to say, we don't do that in this country. We don't insult races and religions and genders. So that's one thing. The leadership must speak up. And I think we have a problem of silent leadership in some areas. Secondly, administration. Administration must be equal. Justice is not in legislation, but in administration. So I have no particular desire to introduce more and more laws. That's why, Andrew, even in my area on the harmony, I was not talking of introducing more and more laws to punish hate speech. I was talking more in terms of a social harmony law that would bring people together. But in general, I agree with you on both points. Social hostility is rising. And secondly, there's really no need for more laws, though the social harmony law would allow, as I said, allow us to come together. Like, for example, Suhakam. Suhakam not only reports, it also conducts lectures and educational courses to sensitize people. Thank you.
Thanks, Prof. And just to pick up on that note about social harmony, right? One of the points you raised earlier in your presentation had pertained to the Rukun Negara being preamble to the Constitution, right? Your suggestion for it. All right. Andrew again had drawn a comparison between how Indonesia's Pancasila being the founding philosophy of the nation, which was the case before independence, while he alleges that the Rukun Negara was a result of the 1969 riots, and whether it would make sense to retrofit this, in his words, politically arisen Rukun Negara onto the Malaysian constitution. Maybe some thoughts on that, Prof.
Well, actually, ideally, there should have been something like the Rukun Negara in the Constitution of 1957, 1963, when Sabah, Sarawak, Singapore constituted the nation of Malaysia along with the Malay states. Yes, but since that was not done, perhaps they didn't have a preamble, because normally preambles say, we the people of such and such state, and our constitution was not submitted to a referendum. Our constitution was actually adopted, first of all, by the British Parliament, then by the Federal Legislative Council, and then by the assemblies of all the states. So because there was lack of popular participation, maybe, that's why there is no such clause as we the people of Malaya or we the people of Malaysia. Well, why not adopt it today? And Andrew, there'll be no need to backdate it, adopt it from today. Adopt a new preamble from today, because after all, preamble is not really strictly law. It is a pole star for action. It is actually a guide, an ideal. It can act as a guide to interpretation, but its terms are not strictly speaking law. Why not adopt it today and for the future generations? And judges could then refer to the preamble for interpreting the Constitution. For example, on so many issues of race and religious disputes, which are proliferating, our judges have not been very helpful in trying to walk the middle path. And I think the Pancasila type of document, a Rukun Negara, would certainly be able to assist. I don't see any harm whatsoever in adopting the Rukun Negara, because I sincerely believe that most of what the Rukun Negara says is in harmony with the Parlembaga. Of course, there are some aspects of the Rukun Negara which are not in the Constitution. For example, the reliance on science and technology. That's not specifically mentioned. I think much of what the Rukun Negara says is in harmony with the Constitution.
Thanks, Prof. We have a question from Carl Nazarin, saying that South Africa, Indonesia, and Kenya's constitutions seem to give much more foundation to socio-economic rights such as housing, water, food, health, public welfare, and environment. Meanwhile, there seems to be far more presence of civil and political rights in our constitution here in Malaysia. Do you think there's need to update socio-economic rights or provide a stronger socio-economic foundation in our constitution? Or would it be enough to depend on individual legislations and all court cases?
I fully agree with you. that our Constitution of 1957 and 1963 primarily emphasizes what is called the first generation civil and political rights. The second generation socio-economic rights are generally not found in our Constitution. And some people have correctly observed that actually that's an omission, because food is as important as freedom and bread is as important as the ballot box. However, many of these socio-economic rights are found in ordinary legislation. So, for example, Employment Act, Industrial Relations Act, Domestic Violence Act, they do cater to the socio-economic needs of the people. Now, should we incorporate them into the Constitution? I would, as a student of constitutional law, have no objection whatsoever. In fact, I'd be delighted if the Constitution were to be amended to incorporate socio-economic rights. In fact, I would go beyond, besides socio-economic rights, development rights. The third generation development rights should also be incorporated. By the way, human rights are an expanding frontier. They are a journey, not a destination. So I'll be very happy. But of course, much depends on the drafting. The drafting will have to take care of one thing, and that is this, that you've got to tie these rights to the ability of the government to satisfy them. It would be very nice, for example, to say everyone has a right to housing and to make it a constitutional right. Or what if the government doesn't have the money to build houses? What do you do? What do you do then? Do the courts issue an order which the government cannot enforce? That's why in India, what has happened is this, that along with the chapter on fundamental rights, is a chapter on directive principles of state policy. Directive principles. The state shall endeavor to, and they have a long list of socio-economic duties the state must perform. But at the end of the chapter, it says, none of the above provisions are enforceable in a court of law. So the state is given a pole star for action, a guide, an ideal, but you can't have it in a court of law. So in answer to your question, I'm all for amending the Constitution to include, provided we do take note of this, that socio-economic rights have massive economic implications. If you want to give a right, then you must give a remedy. And the remedy must be such that it is enforceable. If it's not enforceable, I mean, what should the government do if it doesn't have the money to build houses for all the poor, or to give a minimum wage of all the minimum wage to all the poor? So I think the law will have to be drafted with care, so that we don't impose on the government impossible goals. Thanks, Prof. I have no problem. I have no problem. Sure.
All right, just checking, Prof, how much more time does you want to spend with me here? All right, let's see, what do you have? We have a question from Rashida Hamid asking you to comment on the state of judicial reforms and for your views on the effectiveness of internal checks in the Judges Ethics Committee in addressing wrongdoings in the judiciary.
Sorry, which committee is this?
Judges Ethics Committee.
Oh, I see.
Yeah.
Actually, I not so sure how to answer that. Judges are subject to discipline under the Constitution. On the advice of the Prime Minister, the Yangi Patanagong can order a committee to be constituted consisting of brother and sister judges, minimum 5, either abroad or local. But after the Tun incident, Constitution was amended to provide a second procedure. And the second procedure is that the Chief Justice has been given power now to investigate judicial misbehavior which does not warrant dismissal or removal. And that is a judicial code of ethics, a little bit unsatisfactory that it is drafted not by the judges themselves, but by the young Dipertuan. So there is a judicial ethics rules, there is a judicial ethics committee, and it has been, it has operated. I'm not so sure how openly. I am sorry, I have never read a report about it. So basically, in answer to your question, what I'll say is this: at the moment, there are 2 separate procedures. One is under the Constitution, the earlier Constitution, where the Agong would appoint a judicial commission. Second one is the Chief Justice has very wide discretion to enforce judicial ethics rules against judges. And I think there is one committee sitting right now. I would think both committees should be subject to the rules of openness, fairness, impartiality. There should be representation allowed, and I think the reports must be made public so that there is so that we know what were the facts and what was done about it. There is certainly no harm in creating a parallel mechanism, provided it observes the principles of openness, fairness, and impartiality.
Thanks, Prof. Earlier you had mentioned that democracy does not necessarily produce a government of the people, by the people, and for the people, right? Now it's like it's all for the elites. Nur Jana Chew had raised in the question and answer section, how do we ensure that people of integrity and positions to make a difference in our imperfect system and structure?
Pray hard. No country of the world can actually ensure that. Sadly, laws and institutions are never enough because they have to be administered. What we can do is to point out the abuses, a free and responsible press, a more effective parliament. I'm hopeful. If you look at each of the check and balance mechanisms, each is not working well by itself. But if you put them all together, you were to improve all of them, put them all together, that may constitute a torrent of pressure on those. So, for example, if there was free press, strong public opinion, a more vigorous judiciary, more NGOs, I think together the pressure will be there. And in some areas, I can say this, in some areas, we can clearly see that pressure is working. For example, women's rights. Much more needs to be achieved, I know. But in the last 20, 30 years, much has been achieved. I know that in the 70s, if you were to talk about consumer rights, you were an anti-development freak in the 70s. Consumer rights meant you are anti-development, you are anti-government. But now actually, the idea of development, sustainable development has become part of our vocabulary. So I'm hopeful. All that I would say is this, in conclusion, is I think we all have a role to play. And we rely too much on the government, rely too much on the official media. I think now with the techniques available to us, electronic techniques available, I think we can garner, we can mobilize public opinion and garner support for movements.
Thanks, Prof. Okay, it's close to 11:50. That means I think we've gone slightly over time, but I think let's just wrap this up with one last question, Prof.
Sure.
I think also because it's nearing Christmas time, right, Prof, and to build on what Jeremy Ribeiro had asked, what would be the biggest, the most needed reform in your opinion, Prof, that we should be passing in this country? Imagine if Santa were to come, maybe the law reform Santa were to come and grant you one wish. What would it be, Prof?
Such type of questions are very well intentioned indeed, and I'm not so sure I can answer them. I personally believe no one institution, no one law, no one reform can solve the problem. I think it has to be a collective effort of many institutions coming together. In fact, at the very outset, I mentioned to you, not only law, you have to get education going. You have to educate kids in schools, primary, secondary. The politics has to be reformed. Education has to be reformed. Family life has to be reformed. So I don't think there is one big panacea for our ills. I think we need a lot of reforms working together, feeding on each other, bolstering each other to solve the problems of society. Today's talk was basically about law reform, but actually along with law, we need to improve our education system. You can have an environmental qualities act, but if our kids know nothing about environmental responsibility, I think our religious leaders need to be recruited. I take note, people go to the masjid, on the way to the masjid, they buy a plastic bag of drink, they're drinking on the way. Before they enter the masjid, they throw it in the drain. And they're going to go and pray. What happens to the plastic bag? So I think we need to recruit religion. We need to have education system, the economic system. All of these must work together. I apologize. I won't be able to give you one magic formula for solving our problems. No. Thank you.
Thanks,
Thank you
Prof.
very much.
Thank you. All right. Thank you everyone for the questions that you shared with me. And with that, the Tun Hussein Onn Chair Public Lecture on Reforming the Law to Meet Contemporary Challenges comes to a close. I would like to thank once again Emeritus Professor Datuk Dr. Shad Saleem Faruqi for his public lecture and for everyone for staying throughout the proceedings this morning. Have a good year-end break, and I hope to see you soon. Bye.
Thank you very much.